Hello, and welcome to the second part of the video on the overview of the arbitral process. In the first part, we have seen the progress of the arbitration from the initiation till the first procedural conference. As we discussed in that video, the remainder of the arbitration is not set in stone, and the parties with the tribunal has some flexibility of molding that process to their convenience. But in a typical arbitration, after the first procedural conference, the parties are invited to make detailed submissions. Usually, when the first notice of arbitration is issued, parties don't always provide all the requisite details or all the requisite documents. Therefore, normally they require a more detailed submission to be filed. Please note that this is not necessary. In a small matter, it may in fact be preferable that the parties put all of their information and all of the documents at the very outset so that these stages can be avoided. But if these stages are necessary, then they can happen in one of two ways. They may either be simultaneous exchanges or sequential submissions. Now, what is the difference between them? In a simultaneous exchange, both the claimant and the respondent file their submissions at the same time on the same day. There may then be a scope for a reply submission where each party responds to the other party's submissions. On the other hand, in a more traditional form of exchange, normally the claimant would file its statement of case, followed by a statement of defense by the respondent and a possible rejoinder by the claimant. These two approaches have their own advantages, so depending on the requirements of a case, either or approach can be adopted. The next stage is a witness statement. Now, it is not necessary that a witness statement has to follow the pleadings in the case. In what is called a memorial approach, it is possible that while you're filing your detailed statement of case, you also file any witness statements you may have. That is an approach that is adopted in certain styles more frequently than others, and in fact, in certain circles, it's called the ICC approach because in a number of ICC arbitrations, this approach is commonly adopted. But if that is not the case, then what happens is once the pleadings are complete, then the parties go into an exchange of witness statements. Much like the pleadings, witness statements may also be exchanged either simultaneously or sequentially. Once the witness statements are exchanged, you then move to what is the meaty bit of an arbitration called a trial. It is possible that before a trial also, a tribunal holds a procedural conference. Now, this is to identify certain logistics of how the trial itself will happen. Now, what is a trial? A trial is the dates when the parties in an offline world physically assemble in one venue and try to cross-examine the witness or make their arguments orally. In order to do that, you can imagine that a lot of logistics need to be taken care of. Parties will have to agree on a date, parties will have to make travel, accommodation arrangements, etc., etc. The procedural conference which precedes the trial is intended to address these issues. During the trial, again, it is flexible how the parties want to take it. But in a traditional arbitration, what one would normally do is start with opening submissions. In opening submissions, parties set out the background to their case to give everyone involved an overview of what is involved. This is then followed by the examination of witnesses. The witness statements that have already been provided provide the witness's version of the events. The events in trial are intended to test the veracity and accuracy of those statements. Therefore, the witness is not asked to restate everything that the witness has said in the written records, but the witness simply confirms that those statements are accurate, and then the ball is in the court of the other side. For instance, if it's the claimant's witness, the respondent's side cross-examines the claimant's witness. In that process of cross-examination, a number of very specific questions are asked to try and test the truth and accuracy of the witness statements. We will deal with this in more detail during the workshop. Once the witness statements, cross-examinations are done, you move to the closing submissions. Parties may either choose to do it orally, that means during the hearing itself they may advance certain arguments, or they may choose to go back after the hearing, study all of the records of the case and then make a written submission. These written submissions are what are normally referred to as post-hearing submissions. The post-hearing submissions are not intended to be a summary of the entire case. They're intended to capture the essence of the case and drawing from the strands of everything that the parties have learned during the life cycle of the matter. The tribunal may also pose very specific questions that the arbitrator wants the parties to answer. In that case, the post-hearing submissions also address these issues. Once this is done, the pleadings in the case are closed. Then the arbitrators go back to look at the case and delve into what are the intricacies involved and make a determination of what is the outcome of the case. Now that outcome is converted into what is called an award. In the award, the arbitrators deal with the merits of the case and provide their view on what the outcome intends to be. Now, sometimes the arbitrators, before the award stage, also invite the parties to do what is called cost submissions. Now, you will of course be aware that during the life cycle of an arbitration, a number of expenses are incurred. Lawyers' fees, arbitrators' fees, venue fees, etc. This is intended to get from the parties the cost that each party has incurred. The normal rule is that if a party has won an arbitration, they're also entitled to recover from the other party all of the costs involved in the arbitration. Therefore, in an award, the arbitrators also try and capture the expenses that each party has incurred. These expenses are in the form of cost submissions, and after the cost submissions are received, those elements are incorporated in the award and the award is then finalized. We hope in these last two videos you've had some overview of what the arbitral process has been. Like I said again, the entire process is flexible. There is no golden rule of how an arbitration needs to be conducted. That is in fact the beauty of arbitration. But this should give you some overview of what the expected steps are.